Okay, if you take your seats, please, we'll accomplish the next objective here and then get you out of here by 5 o'clock. Unless you have a burning desire to stay and talk to us some more, in which case we'll stay and talk to you. Just before we take the questions, a couple of people have asked me variously during the day about questions that that are so complex that in many ways there are answers, but the answers are often linked to multiple different systems, and the questions range from how do you help a person who has finished the process of all of the legal manoeuvring and has sort of come out on the wrong end of the stick. What do you do in that instance? And Dr. Kathleen Tierney is going to address some of those sort of matters tomorrow. But then there are other matters that people have asked. Things like, how do you deal with the social services systems and the investigative systems, who often seem like they have greater problems than the parents that they're trying to rip apart? And clearly the problem is that when you get into some of these topic areas, these agencies simply are woefully undermanned, or underwomaned if you prefer the term. But the concept really is that they just don't know what they don't know in most instances. And unfortunately, as I'm sure many of you appreciate, once an agency has taken an early stage position, it's not all that different from what happens in the police department when they think about first arresting you. They have a great deal of difficulty giving up the cognitive dissonance that would be required for them to say, we're down the wrong track. And that's all too often what happens in these agencies. And they can be very powerful and very dangerous. And this whole topic area, just within the array of material within parental alienation, is a massive undertaking in terms of trying to understand all of its dimensionality and complexity. I mean, by comparison, a simple anxiety disordered patient just seems so very easy, because you really don't have to control all that much of the world around that person. There may be relationships that you have to control or bring into bear, and there may be a history that needs to be fully understood in order to be able to track the dimensionality or the emergence of the condition. But when you talk about parental alienation, you're talking about a family system, and then you're talking about a legal system, and then you're talking about a social services system. And if there are allegations of sexual abuse, then we're talking about a criminal justice system. And it all gets very, very difficult. The trouble is, we still haven't done a very good job of helping the judiciary and the agencies truly understand what they're dealing with here. It's interesting that we're talking about the idea of putting parental alienation as a syndrome into the Diagnostic and Statistical Manual. And one would argue, I think, just as readily that if we're going to put it, well, my view is that it really best belongs in the relationship disorders V code. But I think that equally, one should probably apply the estrangement, the realistic estrangement sort of dimension there too, if for no other reason, so that you've got a place to put it, so that you can discriminate it from the more profound states. Anyway, just more to think about. Richard, you ready? I'm going to make a mildly sexist statement. I can tend to read the women's writing better than some of the men's. But I hope that doesn't mean that I'm sexist. What kind of instruments or questionnaires are considered valid measures for the courts in terms of documenting progress in, is that RT? Okay, right, rehabilitation therapy. Yep. All right.
Okay, let me just look at the question.
Short-term memory problems.
I guess the part of the question is the reunification therapy court-ordered where there's well-defined objectives where you could easily measure steps that are defined by the court, or is it a general referral for, they call it reunification therapy, that's really not very clear. If the reunification is defined as a plan, then you can easily define that there's less resistance on the part of the child and what's going on. And the questionnaire that, we have 2 questionnaires that were passed out in the beginning today. The second one, which is open-ended questions, was modified by a questionnaire I constructed for reunification therapists involved in cases. Typically, when I do a forensic evaluation, there's reunification therapists designated as such who have failed to bring about any kind of desired result. So I have a questionnaire that I constructed to ask them the kind of questions related to what's on the questionnaire you have before you in your package, and see what difficulties there are. In one of the cases that I've been working, this is the 3rd reunification therapist appointed. The first 2 have malpractice suits against them. The 3rd one declined, originally was doing reunification therapy, said they refused to meet with either parent and are doing individual therapy with the child that's disinterested in contact with a targeted parent. So in this case, I proposed doing a reunification plan evaluation. So as far as the instruments for documenting progress, if there is a plan, it's movement toward the relationship with the alienated child and the targeted parent, as well as if there's interference attempts by the favored parent, so to speak. If you do not have any such plan, at best you can accomplish is documenting the disruption and what's interfering with the hope of any reunification. And that would be all the sabotaging allegations that the child is saying they're not uncomfortable with the reunification therapist, they don't want to be in the same room with the targeted parent, and these kinds of things where that documentation can go to court so that the judge then does develop a more definitive reunification plan. Because without some structure, it's really a rather hopeless cause.
Can I ask a question connected to that? I realize you have some written questions there, but it's connected to
No.
Really quickly, because I wanted to ask it back earlier, but you're suggesting on the clinical, I agree with clinical evaluations, the assessments and parent coordination. But in Canada, we're a little bit different system here in terms of using either of those, and consent is really critical to get consent from the parties. It's often very difficult. But I'm just wondering, as a point of clarification, are you suggesting that the custody assessor develop a draft of the reunification plan? Because I'm just not, on a practical level, if that's what you're suggesting, we should all be doing this.
Yeah, as a practical, what happens in a custody evaluation, so much energy, time, and expense goes into that. General recommendations are made, and they're left hanging, and then the court says, oh, okay, we'll find a therapist, or find a reunification therapist without any teeth as to what's the next step. So that it would be helpful for an assessor of custody to define, assuming that they can identify alienation or other factors taking place. If it's estrangement, may recommend a parent training course for a particular father and define what the training would consist of, what the criteria would be to assess. There may be a supervisor observing the improved interaction between that parent and that child. So the more definition that is offered the court in terms of considerations that the court can buy into and consider, the better chance of success. Too many custody evaluations or general recommendations that this parent should have more time than the other and have a parent coordinator and a therapist involved without specifying the roles and what that consists of, so you're left with vagaries.
Another way of looking at that is, here you are, if you've done your work properly, you ought to be an absolute expert in the dynamics within this family. You should have a very clear understanding of what you would want to see done in all of the steps that follow after a judge has made his or her ruling. Now, if you simply present the recommendations that the court has to deal with on the issue of where people live and who pays what, that's a custody evaluation by traditional terms, but there's certainly nothing sophisticated about it in terms of making larger recommendations about the long-term interests of the people who you've been working with.
There's still recommendations.
But the recommendations, if they're global, if they're sort of diffuse, are often of little value because the court can translate those any way they want to, and so can the parents. You know, for example, if there was a need for a very specific type of therapist, or if there was a recommendation that a particular person conduct the treatment, that would sometimes be important to know.
Our courts are reluctant to impose things.
Yeah. That's true in the United States too. They do a good job of really imposing very serious and definitive things in the criminal divisions, and they seem to find it almost impossible to reach a conclusion in the family law courts. Yeah.
Just to add to that, whatever the blueprint that you suggest, you have to be able to defend it, because you can expect there'll be an attacking attorney in a non-friendly way to find fault with whatever your blueprint is, and convince the judge that this is why this would be a helpful consideration for this family with the evidence that you found in your custody evaluation. That's why, whether you call it a custody assessment, as they do in Canada, or custody evaluation, parenting plan, a PAS evaluation, a psychological evaluation, or a reunification evaluation, it would have certain similar ingredients and findings and recommendations which you could defend. And if it's alienation, that you want to make clear the degree of severity and what needs to be done, rather than just a general recommendation, because what happens is, as you know, nothing.
That's precisely why a lot of evaluators don't use the word PAS. They don't bring it in. They'll reframe it in a different way, but they won't use that catchphrase, because under cross-examination, it can get very, very nasty.
Yeah,
I'm sorry, but my attitude is, if you can't stand the heat, don't get in the kitchen. Because, it is what it is. And you can call it a blue cow if you want, but it's still exactly the same. It's still exactly the same behavior. There's another suggestion that I have, and that is, even if you think that one party, is roughly the equivalent of Attila the Hun, making that extreme position clear in a sort of an emotional sort of way is definitively against your interests, because the only thing what I think is really important is to have the finesse in the way you present your report, so that somebody did all of these things which in and of themselves are intrinsically unacceptable and very unfortunate and hideous, if you like, but the person, you don't want to vilify the person in the process, because that will set you up for more cross-examination and more compromising than you ever want to even contemplate. from a competent attorney. So you need to show the perpetrator, a tremendous amount of respect in your report, and just try and help the court understand that this person has these unfortunate opinions, and there's hope for him too or her too that they'll be able to, reconsider with some professional attention the distortions that person is carrying. So it's not translated as, in any definitive, unpleasant sense. All right, next one. What?
Interrupt for a moment. I was the author of that first question.
Okay.
I feel that it was answered in the manner that I had asked the question, basically. What kind of outcome questionnaires can you administer to the various parties in order to satisfy the courts? Or is it just a matter of saying, okay, the child appears to be happier, or the child is making more visits with the alienated parent? Or do you have specific psychological measures? Because you were saying there's a difference between outcome measures for psychotherapy and those for reunification therapy. I'm still not clear on
There's
how
no,
do you measure that?
as I said, reunification therapy is so new, there aren't unique measures that are available. What you can do, however, is used in the psychological testing literature. There's hundreds of scales, one of which that I've used is the parent report card, in which the child puts mom and dad and gives a report card during the initial evaluation and then subsequently during the contact. Often the child gives a different rating to each parent when they're brought to the session by one parent versus the other. So there's various kinds of things that you can
And
utilize.
that instrument's useful not only in terms of evaluating the status right there at the moment, but also looking at possible distortions, and it can be the basis for a session in therapy where we try and work through those particular, why did you score the person this particular way, for example? And so we get an opportunity to look at very specific response sets that the person might be demonstrating.
Let's say a child says that the child is fearful of being with the targeted parent for whatever alienation reasons, indoctrination. And as you have successive approximations where they're spending more time, less fearful, and then denying that there's any cause for alarm or fear, that would be something you could document. But there is not, as I know, instruments available to assess that other than pulling out anxiety or phobia kinds of instruments.
We use a SUT scale.
What?
Yeah.
For anxiety, we use a
Yeah,
SUT
you
scale.
can.
Yeah.
Yeah, there's plenty of instruments out there to monitor present status of adults and children and adult-children relationships.
That would be similar to psychotherapy. Psychotherapy and evaluation.
Right.
Capacities, and there's all kinds of different instruments. So for psychotherapy, what you're saying here, it's similar to RT if you're going to be measuring progress in outcomes, because you want to go into the psychological testing and measures,
Yeah.
right?
Yep. Yeah. All right, let me go to the next one. What to do if an alienating parent with an adolescent child involved refuses to participate in an evaluation process, even if the judge suggests it? It's an interesting question because it's my general understanding that judges suggest with the intention of ordering if you don't comply. How can you then make a reunification therapy plan, basically, if the alienating parent doesn't want to be a party to it?
Okay. Well, it's a challenge whenever we work with adolescents, because we know that adolescents don't want to be there. So it's how to get that adolescent to participate. And each of us have our bag of tricks that we use with adolescents. And I always, well, in this situation, I take a approach that might be classified as Peter Columbo, or Peter Falk's approach, using Columbo, not wearing a trench coat, but just bumbling along and say, I don't know why you're really here, and why do you think that we're here, and see what they're going to say, and see if they'll even support the party line that their targeted parent is terrible. And I'll say, well, that would be helpful to know. Please expand upon all the reasons why you feel it's best not to have contact with that parent. And generally, they'll open up in that kind of way. Whereas if you start by arguing with them or trying to find an opposing position, they'll be less likely to speak. I even have a questionnaire on alienation where I'll start with a rebellious, resistant adolescent saying, maybe jot down some notes of what it is you know about alienation. What's this all about? What have you heard about it? And with a family where I did an evaluation of a 14 and 17-year-old, the 17-year-old knew Richard Gardner's writings thoroughly, and she was ready to argue with me. So I just said, good points. What other points should we make? Well, I want to jot that down. I've read some of his stuff. I'm not familiar with all of his things. And she gave me a lot of points to consider, justifying the reasons why she was not alienated. So there's just techniques of working with adolescents to get them to talk. Ultimately, they will talk because the court has ordered it, and it's the favored parent's responsibility to get them to speak. The targeted parent will be ineffective, but a favored parent is going to be able to say, this is what you need to tell the doctor.
There are two comments I'd like to add. One of them is that the use of paradox with adolescents is often spectacularly successful because most other things aren't. And you really have to be sort of mildly sociopathic to outmaneuver them. And I have a funny story I'll just share very briefly. I had a young kid of 15, and he was determined that he was going to say absolutely nothing. And I sort of bantered with him for about 5 minutes and then decided, this isn't going to go anywhere. And so I said, well, look, I tell you what, seeing as we're going to be here for about another 40 minutes, and your mum's sitting out there in the waiting room, would you mind if I did some other work? And so I literally pulled up another file and started opening it and pretended that I was working. And I let this go on, and then I actually did start working because I'm not going to waste my time. So I'm doing this, and then the kid sort of says to me after about 4 or 5 minutes, what are you doing? And I said, I'm working on this file. You know, I've got a really good scam going here. And he says, what do you mean? I said, well, look, your mother's paying me $300 an hour. This guy who I'm working on is paying me $300 an hour. If you were going to talk to me, I could only make $300 an hour. Now I can do 6. And he said, you shitting me? And I said, no. And so I said, well, but you know, just sit there. You know, let me get on and do what I need to get done here, because you know, talking to you is interrupting what I'm trying to accomplish now. So about 3 minutes later, I looked up and I said, what do you think of this? And he said, I think what you're doing is wrong. And I said, now hang on. Don't you think that there's something that you might be able to learn from a guy who gets paid $300 an hour to do 2 jobs at once? Now, you have the choice. You can reduce my fee by $300 if you want to talk to me. And then I thought, should I pay him for this? And I said, I'll tell you what, I'll do one better. I'll reduce my fee by $300 because I'm just going to talk to you, and I'll pay you $20 if you have a good discussion with me over the next 40 minutes. And he said, you'll pay me to talk with you? I said, sure. I'll get it from your mother. No, I didn't say the last part. But my point is, whatever it takes. You just have to outsmart them. Now, in other situations, that wouldn't work at all. But I knew that I had a sort of provocative kid on my hands, and he would really, ultimately, he really wanted to talk, but what he wanted was control. So you have to maneuver the control away from him by giving him the opportunity to have control, but not on solely his terms. That's an example of the sort of paradoxical procedure that I would argue often works very well with adolescents. Okay, ready to do the next one? Is there any way to prevent the alienating parent from preempting the individual's involvement in the therapy and evaluation? Who asked that question? You right? Can you just, I understand what's said here, but could you just give us the context a little bit more?
Well, often the alienating parent will actually preempt the whole situation and gain control of it, and gain control of the professionals that they're working with. Is there any way to stop that from happening?
You want to?
Okay. I guess I was thinking about a number of different things. I usually choose to meet with which parent I think is the alienator first. So that way they're not as defensive as to say you met with the other parent, so I'm going to argue this point or that. And in a somewhat paradoxical thing, sort of show an interest in what they have to say and indicate that that's quite important. So I get their position right from the start. And that is helpful to initially have some kind of an alliance with that person. However, it's short-lived once there's progress with the reunification or the targeted parent and the child or children are unwilling to see that parent. So that's where there needs to be some court order indicating that it's a required compliance of participation, or that you as the therapist have the flexibility to have less contact with that parent and more with the targeted parent and child. Then what happens is you're still competing 1 hour a week with the influence of a skillful alienating parent, which makes it quite difficult. So you may suggest something that when there's visitation with the targeted parent, there'll be no contact with the other parent. So at least that's pure. And then start to work along those kinds of lines. And each recommendation needs to be documented in such a way that you have the court backup, because you can expect as you make too much progress, that alienating parent will sabotage the therapy, refuse to continue, say the child doesn't like you anymore, and find some reason to stop therapy. Then the court will see, well, they tried, try another therapist. And then you go through this all over again.
One of the things that I think you can do that parallels what Richard is saying but is totally removed from it is a systems issue. And that is you try and find a consultant who is likely to have the ability to size up prospective people who may be whose names may be put before the court, and try and make sure that you find the very best, most skillful person you can find. Because there is absolutely no question that this is a difficult arena in which to play. And you know, somebody who's not quite up to the mark and does the job, you can almost guarantee you're going to spend a bunch of time and a bunch of emotion and a bunch of money, and you'll probably not have much of an outcome.
What makes it difficult is the court asks each attorney for 3 names. And if the attorney for the alienator knows that their client is involved in this kind of mischief, is going to suggest names that they can manipulate, that are not skillful in this kind of thing, that'll play the game for the buck or whatever to keep the therapy going, ineffective as it may be. And the judge is not going to know, here's 6 names, licensed professionals, and you could argue which one what. It's very difficult to find or get appointed the person that you feel is competent and will handle this. That's why, as I said in my presentation, with severely alienated children, it's best that the targeted parent solely choose which therapist, saying to the judge, the targeted parent needs to feel most comfortable in selecting a therapist that they can work with and they feel that the child will be comfortable with, rather than a consensus and agreement.
This next question is interesting, and it says, it asks, does reconciliation therapy necessarily have to occur in a custody court context? Is it possible for an alienated child, adolescent, and targeted parent to participate in reintegrative therapy on their own initiative?
That's a good question, and if it's a case of estrangement or even mild alienation, you may have the cooperation to do it voluntarily. But to understand that when you have a moderate or severe case of alienation, to use Dr. Darnell's term, that this alienator is obsessed with disrupting the relationship between the children and the targeted parent, there's no way it can be voluntary. They're going to interfere with it. And even if they do it in a way saying, I'll show the court that I'm willing to do this, it will be sabotaged and it will not succeed. So it depends on the nature of the difficulty and the diagnosis. If it's abuse, the other parent, the non-abusing parent, may be very willing to participate and work out a program that's going to work so that the abuser ceases abuse and there's safety for the child and they can enjoy other aspects of the relationship.
You mentioned that PAS has no history. I'm not sure that that was ever mentioned. But
Reunification does.
yeah, excuse me, okay. Could we assume, though, that sometimes children could copy and impose the parental alienation that they have experienced to their own children? Why not assume that such experience could in fact be normalized by some children? That's a good question.
Well, children, we always learn through observation, so that certainly in the literature, things we learn as a child, whether it be neat or responsible, we grow up to be either neat and responsible adults or just the opposite. So that early learning can certainly make a difference. In the case of alienation, I would hope that the adult that's been alienated or that has lost contact with their targeted parent would be well enough aware not to let this occur again and be aware of it and take various steps to prevent this. It's hard to believe that they'd be so naive not to observe what happened with them as a child and see that take place all over again. The cases where these adult children that have been alienated are very sensitive to what they've been through and want nothing less than this to occur again. And it'll go to all kinds of extremes. And often I call an educated consumer someone that's been through years of litigation and learns it all, but these children that have been victims of alienation themselves, they're fairly aware. So it'd be surprising, even though there was a case discussed earlier today where that was the case.
These questions are so long, they probably require a book response. Let's see if we go. Mark Roseman? Is he here?
Yes, it is.
Glenn Caddy is having a little trouble with Mark Roseman's handwriting. I've got the general gist of it, but I think it might be better if you sort of express the question again.
I forgot the question.
Okay. See me later. All right. We said we were going to...
Oh, I remember.
Too late.
Senior moment.
All right. How about you be the last questioner, question asker?
Case where you're thinking, Dr. Sauber, early on about the parent, and I forgot your phrasing, I think the parent was detached, may have been, they had substance abuse issues, and I forgot the name that you would use for that parent, but a situation where you have a parent who is an alcoholic, competes with the child in game playing. The child might be 5 or 6 years old. How would you deal with that child or with that parent in therapy who has an alcoholic history, is not working, is narcissistic, is extremely charming and eloquent, and has no parenting ability that is developmentally appropriate for that child?
What I would do is the attorneys involved, we would request a psychological evaluation of all the parties. And through the psychological evaluation, it'll become clear that one of the parent has a substance abuse problem and may be able to identify narcissism and other difficulties right from the start, because there is some impasse at some point. And custody evaluations sometimes include psychological evaluations of the individuals. Others, there's more of a cursory overview of the individual functioning. But that would be a case where instead of a custody evaluation, ask for a psychological evaluation of the parties and then see what the results would be.
Yeah.
If that is already known about that parent,
What?
if those,
Well,
the parent is narcissistic, if the parent is alcoholic, although it's not inebriated when coming to the site, how should that therapist or third party dealing with this interaction between the parent and the child control for the
Well, hang on, let me ask a question of your question. Is it the case that this person has already been through a comprehensive psychological examination in the context of this court proceeding or not?
I believe that they had that in the past. They had supervised visitation for 6 years.
Okay. Okay. Then I'm I'm going to suggest that they still need another psychological evaluation, because a 6-year-old evaluation is going to be of little significance to the court. It's going to be relevant in history, what the findings were. But again, after you finish the examination, you do not want to cut that person into small pieces. You want to describe the limitations of their functioning, make recommendations for some professional assistance to be given to them so that they can most effectively fulfill the role that, in parentheses, they are claiming to wish to have. So that, you can certainly talk about the limitations that they bring to the table and the help that they need in order to master the tasks of fulfilling the opportunity to be an exceptional parent. That way you don't piss them off any more than you need to. Okay.
That's a good.
I think we piss them off is a very professional term. But anybody who's worked in this field knows how easy they are to get pissed off. I think we should stop there for the evening. If any of you have any questions that you'd like to come up and ask any of the panelists, please feel free. We probably want to go and leave and have a drink or something relaxing in the not too distant future. So if you could sort of make it short and sweet, that would be wonderful. And we will see you all. We'll see all of you who are challenged to come tomorrow.